Well, that's the matter into which we're sinking our teeth this morning. The VAT controversy, value-added tax, continues even as the matter is in court. Do not forget that the River State government, yes, approached the Federal High Court in River State, got judgment in your favor with regards to the VAT. The FIRS has since appealed. The court is hearing the appeal, but it would seem in a counter move, the River State government has taken the matter to the Supreme Court for determination. The matter is still being, so the matter is being heard somewhat at the Court of Appeal on the grounds upon which it was heard in the Federal High Court in River State. And then the Supreme Court also has the same matter before it. But we're going to be asking the practitioners, tax practitioners, how they view this matter. Joining us this morning is Mr. Samuel Agbeluyi, who is the Vice President of the Chartered Institute of Taxation of Nigeria. You're welcome to Sunrise Daily this morning.
Thank you. Good morning.
Good morning. Well, your institute hasn't been quiet. This morning, you were quoted in the dailies as having said that indeed status quo is what the Court of Appeal has said should happen, and so you've told your members or those who should pay tax to remit their VAT to the federal government. Is that correct?
Exactly, that's correct. That is our position. The rulings of the Court of Appeal is that the parties to the issue should maintain status quo. And what is the status quo? What have we brought to the court? What is the matter in issue? The matter in issue is who should collect VAT and who was collecting before now, Federal Inland Revenue Service. So if you say no state has collected VAT, so if FRS has been the agency collecting VAT across the country, so the status quo is that FRS will continue to collect.
Is that on the advice of your lawyers?
It's both the advice of our lawyers and the stand of the institute. Because when you say maintain status quo, the essence of maintain status quo is that before we determine the substantive issue, can we preserve the rest? What is the rest in this case? What is the matter in issue? And the matter in issue is simply who should collect VAT. Who has been collecting? Federal Inland Revenue has been collecting. State has never collected. So if we should maintain the status quo is that FRS should collect pending the determination of the case in either Court of Appeal or Supreme Court.
It's a pretty tough one for practitioners because as it stands right now, you know, a number of states, 2 states at least that we know, have finally passed their VAT laws. In the wake of the judgment obtained by the River State, well, given by the Federal High Court in River State in favor of the River State government, they went ahead to enact a law, you know, empowering them to collect VAT. And that was before the matter was taken to the Court of Appeal. So isn't there a problem? Do you see a cog in the wheel of the directive which you have given to your members?
No. If anything, we have in tax administration, there should be certainty. And in any case, in any country, in any society, there should be certainty. And for VAT, as important as it is, a tax type that gave the country 1.5 trillion in 2020, we can't afford to be trivial with it. Now, just like I said before, who is been collecting? There's no ambiguity. FRS has been collecting. So, and if we have nothing against, we are not standing for the state, neither are we standing for the federal government. But we need certainty. And the business community are going through a lot of issues. So the least we can do is to assist them, remove the crisis, remove the hostility in the environment. And today is the 21st day of the month of September. This is the last day that, by law, August return, VAT for August must be paid, must get in today. By law, anything paid tomorrow will attract penalty and interest. So the court, if you pay to Federal Inland Revenue as we speak, you have the judgment of the court backing you. And in order to remove the ambiguity or the anxiety or the confusion within the system. We have directed our members, about 25,000 members, who are practicing across the country, to stick to what the law says. In any case, whether it is VAT or any other thing, taxation is essentially law. And we must be guided by law. And Nigeria is not a banana republic. If, for example, I don't want to draw into the issue, but if, for example, FRA has been collecting since 93-94, then I think it wouldn't amount to any big damage if we wait for a month or two for the court to adjudicate, so that the cost will be clear for everybody to know.
Okay. I'm just wondering now, first and foremost, you just mentioned how important the VAT collection now is. It has grown into the trillions, thereby causing not just an upheaval in law, but also a political upheaval of some sort. Now, some people will say that this was predicted. We saw this coming, so to speak, because it's not the first time that a state government was attempting to challenge the federal government with regards to VAT. Is it something that your institute saw coming and tried to intervene in terms of, the uproar it could cause, the destabilization it could cause for your members, and how this was now becoming an important line item in terms of tax, an important tax component, which was, going to be will I say, a beautiful source of revenue. VAT was becoming a beautiful bride. Looking at what was happening with VAT, did you see this coming, and did you try to, draw the attention of stakeholders to it to see how it could be addressed before it went to the courts?
Thank you. I like your phrase, important line item. We've been on this for quite some time, and I will elaborate more. I know before 2015, 2010, we have seen this coming. You can't be a country like Nigeria and you rely on a monoproduct to finance your economy. In 2013, precisely in Calabar, our theme of the conference was on sustainable revenue generation for the country. And subsequently, we'll be doing this. We come out with a communique at the end of each conference, and we send to the stakeholders, the government and all the stakeholders. So we've seen this coming, and we know there will always be pressure on taxation when the oil ceases. And of course, what is coming from oil is almost nothing now. So everybody is looking at FRS, or the State Internal Revenue Services, to bail us out. So it is not out of place. We expected this, that there will come a time whereby people will be more agitated. People will stay focused more on tax revenue. And of course, it's a good development. It will get bad before it gets good, if I can say that. But at the end of the day, whatever the court adjudicates, we will follow. But again, we are not going to be unmindful of the political aspect. I like an aspect of what Rivers State governor said in your intro. There may be the need to sit down, because federal government is collecting now. There are some shortcomings. Should the state start collecting tomorrow, there are also a kind of shortcoming. I can list 1, 2, 3, 4, although I don't want to go into that. So whichever way it goes, there should be sitting down together. And I think we should, permit my language now, we should get serious as a country. This is an important thing, and we can always talk to ourselves. We shouldn't talk at each other. We should communicate properly. Once the communication is good and right, we can educate ourselves and take the best decision in the interest of the country. Because 6% tax revenue to GDP is awful. Awful even by West African standards. And we also need to introduce sense of urgency. Nigerians are suffering, and we can do better, and we have the capacity to do better. So I would rather we do a lot of talk diligently, and we communicate properly amongst ourselves, so that there will be solutions to this. Nigeria can be greater. For how long do we continue to borrow?
It's a big question in terms of how long we continue to borrow. I'm interested in that talk which you say you had in 2013 about how tax was going to become an important component. But even within the tax basket itself, you know, I do not know whether you were able to pinpoint the fact that VAT was going to become an even more contentious one. That's what I'm trying to drive at.
Okay.
As to whether or not you saw, because Lagos State government had already given a hint when it went to court. Was it something that you thought another state in future could also challenge? Lagos State stepped back for whatever reason after they were told that they shouldn't have sued, not even at the State High Court, but also not suing the proper person, so to speak. Was it something that the CITN already saw and, you know, was already finding ways, especially when you look at the fact that when we look at pros and cons right now of states collecting and federal government collecting, you know, some of your members have said, oh, look, this could result in double taxation. There could be, you know, there could be issues here and there, so to speak. The advantages and the disadvantages for every side of the argument that you look at. But did you see this enough to be able to say, you look, this could happen. States could go to court to challenge this. And, you know, if they do win, this is going to be the implication. Is it possible to have a conversation, you know, ahead of that, so to speak? That's the question I'm asking you.
Okay, let me step backward a little bit. I think about 4 years ago, the federal government reviewed the national tax policy, and the philosophy behind the new national tax policy is to move away from direct tax to indirect tax, and VAT falls under the indirect tax, and that is VAT is essentially consumption tax. And it's about lifestyle. It's about what to do. You can afford not to pay if you regulate your activities. So when the new national tax policy came on board, the essence is to focus on that, and we participated actively in the existing national tax policy. But of course, the aspect of who should collect or who should not collect is not, we can even decide. I just said law now, and we have a National Assembly that needs to play a major role here. We can decide to say, federal government don't collect company income tax again. Once that is our consensus, and we think that through, then that will become the law, and that will become what we implement. So this is within the realm of policy formulation. Policy formulation in tax leads to law. So once the policy is gotten right, then of course, you enact the law, then the implementation takes place. That's where you have the implementation, which is the revenue agency. It's actually the last leg of the tax system, which we call the tax policy, the tax law, and the tax administration. So all we need to look at is to say, okay, what do we want to do? What do we want to achieve? Beyond the revenue aspect of taxation, we also use taxation to direct and redirect economy. So should we think of certain aspects tomorrow, a part of growth, we use taxation to achieve that. I'll give you an example. Stamp duty. We have advocated over and over again that the state will not require bailout from federal government if stamp duty is properly administered in this country. But it's about VAT today. We have also informed our leaders. Property tax is another aspect where you can get money. But we are talking about VAT today, and we are also advising them on stamp duty. We are talking about property tax. Nobody is listening. But because somebody has raised the issue of VAT, everybody is moving to VAT. When we are done with this, we go to sleep again. But over and over again, it has been the responsibility of our institute that we've been highlighting this to the stakeholders.
Well, it looks like it just heard you because because stamp duty, we've seen the attorneys general or the attorney generals of the 36 states now, writing to the attorney general of the federation with regards to stamp duty. But we will come back and we'll continue that conversation after this break. Please stay with us.
Well, yes, we're continuing this conversation about the VAT matter. But we do have Mr. Kayode Ajulo, who is a legal practitioner, to give us his thoughts, his perspectives on this matter. Good morning, and thank you for joining us today. Well, we do know that some days ago, I think the organized private sector did say that they wanted clarity on the matter. I think it was before September 21. But at the moment, you still have some people who feel, look, what do? Do we wait until the entire process is over and done with in the courts, or what? What's your impression of what's going on? It again from the start. Thank you. Yes, we can hear you now.
What the party should do in view of the court's ruling, that is the order by the Court of Appeal. And it is so clear. The court is so emphatic to say that the parties should maintain status quo ante bellum. We have two types of status quo from understanding. One is status quo ante bellum, another one is status quo. Status quo ante bellum, simply stated, is all about it should be that the situation should be before the war starts. And what it means that before the commencement of even the issue. And from that interpretation, what the court is saying is that before even coming to the court, before you start fighting, the situation should remain as it is. And that's, and I don't think there is no any other interpretation for anybody to deceive itself. Those that need to pay tax know where the tax should be paid to, pending when the courts will grant the final judgment. We quickly make the final decision. And as it is, the matter is moving fast. And I know because this is tax issue, no court will sleep over it. And I'm very sure in the next few days, everything will soon be over. And every party will know exactly where the issue is, and the old issue will be resolved immediately.
So whether or not states have signed any of those laws, at the moment, it cannot be implemented until this judgment is over and done with.
I want to believe that since even I believe the states happen to be of the processing courts, and they are already parties. And once the matter is before the court, it is expected that both parties need to maintain that status quo. And like I said, the courts, I'm sure they are aware of the implication of the importance of this issue, this tax matter, and I'm sure the whole issue will be dispensed with immediately.
So if we could just, move through the different, the highlights of this whole event. So Rivers approached the court, the Federal High Court, and the judgment was given in favor of the state. So at that point, I know that FIRS was saying maintain status quo at that point. So when Rivers got that judgment in its favor, enacted a law, what was the fate, or who were the companies or organizations meant to pay VAT to?
Well, the narration has to put in proper perspective. The narration here is mind you, even when you are in Supreme Court, when you are in Court of Appeal or Supreme Court, it is continuation of the issue. What is the issue? The beginning of the issue here is that Federal Inland Revenue has been collecting the taxes, that's VAT, and the state thinks otherwise, and the state happened to approach the court where the judgment has been given to the state, and again the state has already enacted law to say to the effect that that issue of VAT will be superintended, will be monitored, and will be managed by the state's government. Now, with this order of the court that status quo ante bellum has to be maintained, it is wise, it is expected that all parties need to maintain that status quo ante bellum, because I'm very sure the courts will still make decision over other issues as presented by the...
Well, Mr. Ajulo, I understand. I'm referring to the judgment, after that judgment at the Federal High Court in Rivers, which ruled in favor of Rivers State in the collection, and then Rivers State followed up with that law. Yes, Lagos State has also done the same. But I'm saying that in that period, because the FIRS kept saying that, well, maintain status quo, the VAT should still be paid to us. So was that right for the FIRS? And I'm not talking about, in fact, they asked for a stay of execution, and the court did not grant it at that time at the Federal High Court. So in that period, and FIRS kept saying, pay to us. Was that right? Were people meant to pay to the FIRS or the state?
That it is right. Particularly, mind you, the judgment that has been given to the River State as it is before the judgment that has been given to the River State as it is now on appeal. That means that there is the issue. Irrespective of the fact that I agree into two with the River State that this is the position of the law, it is still expected that it must be court order, particularly when the rest has to be maintained. And if the court in his infinite wisdom can make such ruling that antebellum has to be, status quo antebellum has to be maintained, so be it.
Mr. Ajulo, you're referring to the appeal court, and that's the recent one. I'm referring to the Federal High Court in Rivers, and I think you've spoken about this as well. And I just want to be sure, are you changing your position? Are you saying there was never a point where the court said pay to Rivers and not the FIRS?
Yes, you're right. You remember my position right from the beginning is that it has to be paid to the Rivers. And as at that time, we are here to get this extant ruling, that is the order of the Court of Appeal, which is today every lawyer, what is sought, must agree to, must obey. As at the time I made that position, it's so clear that we are here to have any order that says status quo antebellum has to be maintained. And as at that time, what we have is the judgment given to River State, which is subsisting. But immediately it is on appeal, and the appeal has made a pronouncement on it that status quo antebellum has to be maintained. It is expected, if it is status quo antebellum, that is before the issue arose, before the war starts, and it is to revert back. And like I said, it is an interim. It is more or less a tenuous order, which is not permanent, which is not static, which may even be changed, today. But as long as that order is on, everybody needs. It is imperative that it is obeyed. It is imperative that it is followed.
So from the look of things now, it is the case that is at the Supreme Court that you think that will be given that accelerated hearing, and thereafter it will be sorted out.
Exactly. As it is, that's why I said since the party, the jurisdiction now has already moved to the Supreme Court. I'm very sure because of the nature of this matter, it has to be dispensed with immediately. Immediately, it has to be dispensed with.
All right, and thank you very much indeed for your perspective this morning, Mr. Kaide Ajulo, legal practitioner. All right.
Okay, so let's take this back to Abuja with Mr. Gbelui. And I would like to follow up on a question Mokwe raised earlier regarding the history. I mean, looking back in time. And I would say that the CITN has been really present at the very inception, even before the inception of the transition from sales tax to VAT. I mean, the institution was chartered by that Act of 1992. That's Act number 76 of 1992, which is now the CITN Act 2004. So that's a year before we had that transition. And clearly you saw all of this happening. Did you play any role in that transition? Did you see, and I'm taking that back to 1992, prior 2013, which you have referenced. So what role did you play, or did the CITN play in all of this? Did you see that lacuna, as it were, or did you just think, well, it's quite clear? I mean, what role did you play, and did you see this coming as far back as then?
Thank you very much. I know all the way we've been relating with stakeholders as to the best that should be done concerning tax revenue generation in the country. There have been many fashions as to, I'm sure you know 1992 is a long time ago now, but there have been many fashions as to the contribution, the intention of the drafter of VAT decree, now the VAT law, as to who should collect and who should not collect. Mind you, sales tax was in operation before VAT law came on board, and sales tax has been primarily the affair of the state. But the implementation and the coming on board of VAT law has placed the administration of that particular law in the hand of VAT. It's one thing at the point of coming up with a law to make your suggestion. It's another thing to see the final copy coming out the way it's coming. I'll give you an example. The federal government has done very well by giving us Finance Act. That started about 2 years ago, 2019, 2020. The one for 2022 is in preparation. This position of CITN is that minimum tax that the taxpayers are made to pay when they don't have profit to declare should be removed. Because in the understanding and in the belief of CITN, minimum tax payment is a capital erosion. I've done my business for the past 12 months. I've not been able to make money. But despite that, you ask me to pay minimum tax. That is not the position of CITN, but that is the position of the law today. And we will keep on agitating in favor of the system, not just the taxpayer, but the system generally. Because when you are fair in your dealings with people, people tend to trust you more. So the way we have been contributing then, I've just brought you to the recent that we've been contributing. But you can advise, but the advice will not be taken all the time. But what we keep on doing is to keep on pressing to make sure that the system is properly sanitized.
So just winding down now, I'm thinking of combining two questions for you, but let me just try. So I wonder through this whole process, how you've been receiving things. I recall first when that judgment first came, you said you wanted to study the certified true copy and get some legal advice in terms of what to do and what not to do. And you have made your position clear now. So I wonder, was there any time where you were thinking, okay, well, based on this judgment and based on the law that have been enacted in Rivers and Lagos, perhaps these, the VAT should be remitted to the state? Was there any time that you made that decision in the light of the information and the judgment you had?
Like I responded to the question, your question is similar to what my query raised earlier. The best thing an institute like CITN can do is to be neutral and be fair to all parties. Once there is fairness, the system will run properly. When the judgment came from Federal High Court, Port Harcourt, there was we wouldn't respond. You are in the main media house, and you don't respond to social media thing. So we waited for certified true copy. And about when we got the certified true copy, the appeal came. and the appeal put things in perspective. And I'm happy with what the contribution from Mr. Ajulo also, which is similar to what CIT is doing. We can do without the confusion, no matter the way, the sentiment around it, we can do without the confusion, so that we need a stable system. The investors are watching the country, and somebody must have his head properly in order to ensure that we don't give that kind of impression that if you take your money to Africa or to Nigeria to invest, you are not going to be sure of what happens. Anything can happen at any time. So
I think indeed that's an important point to raise, as you have raised.
And we are sticking to the outcome of the judgments from either from Federal High Court, Port Harcourt, and Court of Appeal.
Right. So on the other side, the second part of the question, quickly. So do you see this as a win-win situation, whichever way it swings, or a win-lose situation? And I'm talking for not just states and federal government, for states and other states, because it's looking like, some states are for collection of VAT by states. Some other states are for collection of VAT by the FIRS and SHED. Is this going to be a win-win situation, a win-lose situation? How do you see things playing out?
Well, the Institute will work to ensure that we have win-win situation, and we can achieve that. But if not properly handled, it can be win-lose situation, because we'll be talking about capacity. We'll be talking about taxation is technical, and VAT particularly is multi-layer tax type, and the nature of the country, 36 states in the country. Don't forget, Adam Smith talk about economy of collection of taxes, even way back. So all this we need to put together, and it's a whole lot of work. But our focus is to make sure that it's a win-win situation, and it is achievable. And we have the capacity. Nigeria has the capacity to make this thing win-win situation. All we just need is the good intention to do that. We can make it win-win situation.
So I'm just wondering now, what do you think is going to, excuse me, what do you think is going to happen if eventually, whichever way the courts rule, but if this is done in favor of the state, how do you think it's going to impact your organization? Are you already projecting to the outcomes, the possible outcomes of the matters in court?
The state will have a lot of work to do. One, there must be a lot of capacity building. That is not been there. Maybe about 3-4 states can proudly say, okay, now that 6 months, we take off properly. So capacity building. And whether we are talking about VAT or other tax type, the state internal revenue services, at least permit me to mention this, needs to give autonomy to the various internal revenue services, that the state government. The era of appointing somebody from your political party or from your zone to be the chairman, that is a very important office. Everybody is talking about what FRS is doing today. FRS is not just doing magic. FRS has autonomy, and they have 4% cost of collection. So they can hire fantastic staff, skilled staff from anywhere, outside the country, within the country. They can fire. So once you have that discretion and you are giving target, you will perform. But the state will have a lot to do. I know it is possible, but it is not just to wish. You bring somebody without background in taxation, in finance, to run your internal revenue services. I have states in this country that, as we speak, they don't have substantive revenue chairmen for 3 months, 6 months, and you are in the business of collecting revenue in this year 2021. That's not a serious thing to discuss. So should it go to the state, there will be need to do a lot of work. So, and the governor, you make your life better. This is an advice, an appeal to them. You make your life better if you do the right thing. Don't politicize the office of the chairman of State Internal Revenue Service. FRS is looking beautiful now because the federal government has made it so.
Well, I think it's a very good advice to give, and I'm sure that states will start preparing themselves for the work that lies ahead, especially in the light of the word that oil, the revenue from oil is not looking as pretty as it used to look, and taxation, it would seem, is now the new bride. But we'll see how matters eventually pan out on that one. We have to thank you so much for coming on behalf of yourself and your institute this morning. Mr. Samuel Agbelu is the Vice President of the Chartered Institute of Taxation of Nigeria. Thank you so much for coming on Sunrise Daily.
Thank you very much.
We'll take a break at this point. We will come back and we'll have our teeth in that matter of inoculation. Don't forget our correspondent, Gloria Imuzuki, brought us up to speed with regards to what the president will be asking for. But there are other issues, it would seem, standing in the way of achieving more than 4% for Africa. We'll sink our teeth into some of those when we come back from this break. Please stay with us.